I want to take you to Munich in 1984. It's December, and at the European Patent Office, a small group of lawyers faced a deceptively simple question, but one that would change the future of medicine. The EPO's job was to grant patents to new inventions. For pharmaceuticals, that meant new drugs, new vaccines, new compounds. And for decades, the EPO held a firm rule. You can patent the drug, but not how doctors use it. Patent the molecule, yes. Patent its use as a method of treatment, no. But this rule meant something profound. You couldn't patent a new use of an old drug, even when that new use saved lives. No second patent for this condition, no third patent for that condition. The drug was already spoken for. But by 1984, researchers had begun discovering extraordinary new uses of old drugs, reimagining, repurposing, retargeting old drugs in new ways. You see, the science was moving, but the law was stuck. And without patent protection, companies might not take the risk developing these new treatments. Patients could spend years waiting for these life-changing therapies or miss out entirely. So the European Patent Office faced a dilemma. Do they stick to the purity of the rule? One drug, one patent. Or do they adapt and create protection for new uses of old drugs? And why does any of this matter? Well, this is a story of a tension at the heart of modern medicine, the tension between innovation and the limits of the law. And today I want to argue that those two forces, pharmaceutical innovation and patent protection, are not enemies, but partners, interdependent, each one enabling the other. So here's what I'll do. First, I'll explain exactly what a patent is, and then we'll go back to that December day in 1984 to look at what the EPO eventually decided. And then I'll bring us up to date with a recent case from the Supreme Court, which I believe expels out exactly why this matters, not just for drug companies and lawyers, but for all of us. So what is a patent? Well, think of a patent a bit like a permission slip. If you invent something genuinely new, the government will give you permission to be the only one allowed to use and profit from that invention for a period of 20 years. In exchange, you must reveal your invention to the world, how it works, how it's made, and how it can be used. And for the pharmaceutical industry, patents are more than legal documents. They're the financial engines that make new medicines possible. They allow companies to recover the billions of pounds spent developing a drug or vaccine, and for those 20 years, no one else can make the drug unless they're licensed to do so. Now, to get a patent and that 20-year permission slip, an invention has to pass three classic tests. It must be novel, so genuinely new, must be inventive, so it can't be obvious, and it must be useful, capable of what's called industrial application. And it mustn't fall into one of the excluded categories, such as methods of medical treatment. And here's our classic challenge: the new use of old drugs. You see, the drug itself is not new, so you can't claim the drug. And you can't claim the use of the drug in the new treatment, well, because that's excluded by the law. So how do you protect a new therapeutic discovery when the law seems to block every route? Well, back to that cold December day in 1984 and the dilemma that the EPO faced. Well, they decided to do something significant. They decided to create a new type of patent. Not for the drug, but for a new way to use an existing one, a so-called second medical indication patent, a new life for an old medicine. And suddenly companies could protect an old drug for a new disease, at a new dose, or for a whole new patient group. But what I want to argue today is, whilst the theory is clear, in practice these patents create complex questions, as our example in the Supreme Court reveals. Now, our example is a drug called pregabalin. Now, pregabalin was first patented in 1993, and 20 years later, that patent expired in 2013. So for those 20 years, only the inventing company, Warner Lambert, could make and sell it. And doctors used pregabalin to treat anxiety and epilepsy, and the drug worked well. But as the patent was nearing its end in 2013, researchers discovered something remarkable. Pregabalin could be used to treat neuropathic pain, a severe and often debilitating form of chronic pain that existing medicines didn't always touch. In other words, pregabalin, an old drug, had a new use as a painkiller. So Warner Lambert did exactly what Munich had made possible. They filed a second medical indication patent. But just like that, the law got tricky. The same drug, two sets of uses, two sets of rules. Epilepsy and anxiety, out of patent. Anyone can make and sell that. That's called the generic supply of the drug by generic companies. But for pain, that was still protected. Only Warner Lambert could supply it. So imagine this. You go to your GP with nerve pain. The GP prescribes pregabalin. No condition is listed on the prescription, and 81% of prescriptions work this way. They don't tell you what the drug is being used for. How does the pharmacist know which version to dispense? And if they get it wrong, who's to blame? The pharmacist? The doctor? The generic company? Warner Lambert argued that, well, everyone knows pregabalin treats pain. The doctors prescribe it for pain, the pharmacists dispense it for pain. The generics are ending up in our protected market, our patents at stake, even if no one says the word pain. So they wanted warning labels on the generics, not for pain, for doctors to prescribe only with the brand name called Lyrica, and for pharmacists to stop giving generics for pain. So the Supreme Court had to answer this rather bizarre question. If a generic company sells a drug legally, out of patent, but someone else uses it for a patented purpose, is that infringement of the patent? The court's decision? Generics were free to sell pregabalin as long as the packaging didn't direct it for pain. A simple label, the outward presentation test as it's known, a legal puzzle solved. But this clash exposed something deeper. One of the great unintended consequences of the EPO solution back in 1984. You see, by creating these second medical indication patents, the EPO solved one problem, how to protect new uses of old drugs. But they created another problem, a legal maze where the same pill can be both patented and not patented at the same time. And in protecting the new patent, the law could unintentionally affect access to the drug for its original uses. Now, it's worth noting that the Supreme Court ultimately invalidated parts of Warner Lambert's patent, but the question of who's liable if the generic is dispensed for the patented use remains a critical issue. So the story of second medical indication patents, from Munich to pregabalin, shows us that innovation doesn't exist in a vacuum. Every breakthrough in medicine interacts with law, economics, and everyday practice. And the very systems we build to reward innovation can sometimes create new dilemmas for doctors, pharmacists, and patients alike. And the stakes couldn't be higher. For the drug company, rewarding and protecting their inventions to develop new therapies is clear. They allow new medicines into the market to save lives. But for patients, these legal debates aren't abstract. They can affect access to medicine, and at what cost. But I want to leave with a hopeful message that patent law is not just a set of rules. It's not just a permission slip that grants you 20 years and that's done. It's a tool. And when designed and applied thoughtfully, it can unlock new possibilities in medicine, encouraging researchers to repurpose old drugs, discover new treatments, and ultimately save lives. But the challenge, which I hope I illustrate here, is balance. making sure innovation is rewarded without blocking access, and making sure the rules of the game evolve as science moves faster than the law. So the next time you take a pill, think about this. Behind every medicine is a story of innovation and of patent protection, as well as human ingenuity. And perhaps with the right balance of law and science, the next life-saving breakthrough is just waiting for its permission slip. Because good patent law fuels innovation. Bad patent law can block it. Thank you.